they can also create a trust for your information. The trustee whom you have allotted can be given power to create another trust by himself, because if he thinks I cannot manage now, he himself can create another trustee of his own trust, and then this will continue. Okay, with this small, I will give the mic to.
I completely agree with sir. Ma'am, questions yours, I understand that being a mother, you need to protect your kid after you, right? Again, I'll come to a point. Private family trust is something where very, very, very carefully you need to select a person to whom you want to give that power after you, that he or she will look after your kid. Regarding PMI, see, ma'am, we cannot control future, but we can get secured for future, right? We can take the steps to protect our loved ones through this private trust, right? And most and more important thing here is, in case of PMI, you can add special clauses only. There will not be a kind of a special clauses, but only the in that case you can go with, like, a trustee along with a CA. Your question was like whether how finances will be managed and who's going to look after and everything. In fact, in Rajesh case, I agree that he had a 2 normal child, but it is not a very different matter in case of PMIs, ma'am. As sir already discussed, like mental act in our India is not so much like oppressed by the government, to be honest. So here we need ourselves to protect our kids, and we need to become a protector for our kids after our death. And to be honest, if I'll to all your questions regarding that, I would definitely like to join you personally, ma'am, that where I can satisfy your all the questions. And moreover, it's all, again I'll say the same thing, it's completely depend upon your choices, that what you want to put in your trust, to whom you want to give your things, controls, everything. I have already mentioned earlier that private trust is not just a legal document, it is a weapon to protect your loved ones. So you need to be very, very careful regarding while drafting it. And I agree with the sir as well that being an advocate, I will definitely going to share, okay ma'am, in your case you need to add this clause. This is my opinion only, but I cannot force you to put that clauses. Definitely I'll be sharing those clauses with you to protect you legally, okay? But I cannot assure, being an advocate or a legal person, that where I can assure that, okay, this trustee will take care of your kids or to PMIs. Regarding the medication and dependency and everything, again I'll come back to the same point. You can terminate your trust anytime when it is breached. So it is kind of a document where we made it very carefully, where every and each of your questions will be got answers. But only the main important point is how we draft that trust deed, what clauses we put in. You can put unlimited clauses, no problem at all. There is no restriction of the pages that you need to stick with 20, 15, 5, 10, no. You can make this much, 200 pages also if you are not satisfied. Until you are satisfied, you can make each and every clauses. But ma'am, we cannot protect future. We cannot go with, like, that assumptions that what is going to, we are finally humans, right? Ultimately something will go. We can only, yeah, this is the, unfortunate fact about being a human, where you cannot protect yourself from future, but you can get secure. But again, I'll come to the point, security is only 99.99%, I guess. 1% is still, like, we are unpredicted, ma'am, to be honest.
Parent had formed a trust, and the trustees were the mother's sisters, Marcies, and very close relatives. 2-3 people were on the trust. Actually, what I'm trying to tell you is there are chances that we may miss out on 1 or 2 clauses. Then what is the scenario? So these are live cases, the 2 cases which I am telling. You can give us the answers. So then what happened? The person who has written, she expired, and the trustees started implementing whatever was in the trust. In that she had forgotten to mention the house, the immovable house, which was occupied by the PMI. And it was not written in the trust, because she assumed that this PMI will continue staying in that house and he will not have the power to sell the house. But she didn't take care of that clause in the trust. Now the PMI suddenly wanted to sell off the house. The trustee didn't know what to do. So that was one scenario. Now they were in the trust deed, it was not written that they have to stop the PMI from not selling or whatever the relevant clause. I don't know the legal language of it. That is one case. So she was lost. She started asking us, because we being friends, she had asked us how to solve this. I said, I don't know much about it. You have to take legal help only, but the PMI has a right to sell the house because the house is in his name. Means after the mother, it went to his name. So he has every right to sell it off. She should have included that part also, that he has no right to sell. He has only the right to occupy the house. That is one case we came across. Second case is the father, he had clearly written that after his demise, the PMI son will be shifted to a rehab, and rehab whatever needs to be given and all that was and immediately it was implemented by the trustees. The PMI was put in a rehab, everything was going fine till 2-3 months. The PMI refused to stay in the rehab and he wanted to come back to the house. That was not written in the trustee, because it was confirmed, because the PMI was around 65-70 years. So the father or the person who wrote the trust or trustee, he thought that that was the suitable, he took the decision on behalf of the PMI. Now he escaped from the rehab and he is back to his house. Next what?
Again, ma'am put it like 3 situations here. First is that trustees were Marcy and near relatives. First mistake, ma'am. Though becoming an advocate, if I'll say, ma'am, okay, I don't think that it is my advice not to put trustee to your near relatives. Will you be able to listen to me? No. You will say, no, ma'am, I have a faith on them. Right? Just like sir said, Ahmed sir said, no, abhi tak to kisi ne kuch kiya nahi hai, I trust. We are Indian families and we belongs to India, and we are living in a society where we take decisions from not here, from here. Still we trust, right? Ma'am, again that Masi automatically Masi, Atama, I don't know, Chinnamma or Atama may be the Telugu word. I am very bad in Telugu, still learning in process. Maybe in next session I'll assist you in Telugu language. But I don't think so. I mean, I am also a mother. I cannot trust my kids with like my Masi and my anyone. So you are the, okay, you have a PMI, right? But your state of mind is correct, na? You're in a good state of mind. That is why that PMI is completely depend on you. That is why what I said, ma'am, you need to be carefully choose the person to whom you trust. No, ma'am, it is automatically you have given every kind of that meal in front of the relatives. Okay, go and eat it. Kind of a thing. I mean, trustee should be someone, ma'am, with a genuine heart, with a neutral attitude. It is not really important that that should belong to your family only. Maybe your friend, very close friend, maybe a neighbor who is just being with you in your hard times. A person who is in your hard times can become that person, not in a person who is in good times. I mean, I have that much. Again, we missed, na ma'am. We missed that clause. That being a parent, we need to decide that we should be aware. Here I will say like 99.99% we can be accurate, but not 100%, ma'am. We can also slip with some things. Yeah, if PMI is not ready to shift it to rehabilitation, so his father would have known that, right? That he is not comfortable with the rehabilitation environment. He is more comfortable in house.
I would like to clarify two things here. One thing is whether it is breach of trust. In the trust selling aspect is forgotten. Okay. And PMI is now cognizant and he wants to sell it. He is in good mind. He is taking medicine and he wants to take his own decision. One thing. Okay, if he is in mania and wants to sell the house, and if the trustee believes that this decision by him is in unstable mind, he can go to court of law, prove and stop that selling as a trustee for the benefit of beneficiary only. So he has to prove to the court of law that this particular property selling is not in stable mind. If he can prove to court of law, then his decision may be in court provided. But if the PMI, who is also have human rights, can engage another advocate, he can also engage another advocate who will prove that, he may prove that his decision is right, he is in good mind. So it all depends upon your trust deed which you are preparing may not can be challenged by only PMI. Nobody else can challenge. But if a PMI doesn't want a trust, he can go to court and say, I don't want the trust to manage my assets. That also can be given by the trust. And a PMI can go to court and squash this entire trust. If he wants, I can manage myself.
Yeah, that should be revocable trust, not irrevocable trust. again the clause came. Yeah, if it is revocable, okay, fine. But if it is irrevocable, then can't do anything.
Trustee and the PMI. The litigation will continue. PMI and trustee. So it is more than the PMI. Now I request Rafat Raja Madam, our secretary, active secretary, and Dean of Ankur University, and so many titles for her. She is also faculty, taking counseling. She takes counseling. She is a faculty in nursing college. And,
Yeah, so we can add here with like that trust, we can add a more medical, we can more concentrate on the clause of the medical situations, ma'am, according to the disease. That here we can manage that clause once we will get the detailed condition about the PMI. So according to his condition, we can make a this trust deed as well.
you understand, please understand that disability certificate is not permanent, because a mentally ill person, once he becomes stable, he is working in office and other places also. So they say if it is disability is 40% or more, then only the disability certificate. So it is reviewed. So you cannot say that he is a permanently mentally ill. That is also there. So anytime the mentally ill person who is the beneficiary can challenge your trust deed if he doesn't want a trust. I am putting it very clear that you cannot brand him as lifelong mentally ill. That is one thing. Okay.
Most important thing is the very basic thing, ma'am. You are aware about your PMI's condition. Like, again, very wisely choose your trustee. Very wisely choose the people to whom you want to give all those authorities again and again. Take your time for before if you are taking decision regarding okay, I want to go with private family trust. Fine, take your time. Think about everything and put it down on the paper. Revise it. Yeah, sure, sir. Because then it again, ma'am, it depends upon person to person. Because in my knowledge, there are multiple kinds of, as you said, or talking about the mental thing. Yeah, if he is working, he is earning money. That is a challengeable in court of law. Easily, where he can break down. Okay. We can, I can personally help you with at an emotional level also. That okay, ma'am, I'm a woman too, I'm a parent too. I can no advocate will do that, but as I mentioned in my profile that I want to literally help everyone. That remember me for their lifetime. Okay, thank you so much. Thank you. So yeah. Oh, ma'am. Ma'am, assurance is finally, I don't know how to put this. But, thank you so much for that respect, ma'am. I'm really very pleased actually. Yeah. Yeah. it it is kind of a like, you're just making a picture and looking for a hero and heroine kind of a thing.
Good morning. Uh, I'm also a caregiver to my son. I have property and it is self-acquired. Like I was saying, I'm a caregiver to my son. I have सेल्फ एक्वायर्ड प्रॉपर्टी है, तो मैं 2010 में शायद एक ट्रस्ट बनाई थी, बट नाउ द ऑब्जेक्टिव्स आर डिफरेंट. सो कैन दैट बी वन क्वेश्चन इज वेदर दैट कैन बी मॉडिफाइड, क्योंकि अभी ये जब PMI नहीं था, अभी PMI है, तो दैट इज़ वन थिंग. And then I would like to have your card so that personally I can meet you and we can go about that.
So to ma'am's question is, again I'll come back to the madam made a trust like years back. Again my question is whether that trust is revocable or irrevocable. If it is revocable, we can modify it, no problem at all. If it is irrevocable, we can go with a cancellation of trust, right? Yeah. Then after cancellation of that trust, we can go with a new trust. So where we can mention that PMI, now the person is literally a PMI. So according to that, we can go and we can put the trust deed and we can draft that.
Number of trustees, like only one should be there, or can we have more? Like sir was also having.
I think sir has given the good example. Many cooks actually they ruin the food. Same, जितने लोग ज़्यादा किचन में आएंगे और वो खाना बनाएंगे, उतने ही लोग कोई मिर्ची डालेगा, मसाला डालेगा, कुछ डालेगा, तो अल्टीमेटली खाना खराब ही होगा. Better you can have only one backup, I will say. Along with that, you can have a like declaration deed. Declaration deed. Along with that trust deed, you can have a declaration deed. Okay, in that declaration deed, we can put like, okay, if this happened, then this is the backup plan. Yes, with plan A, you need to have a very secret plan B. No one should know. Everyone should know, okay, we have only trust deed. Then that paper should come out when we are in a situation of needing that. That is what I called as a backup deed. I mean, it's my word, not a legal.
Yeah. Can PMI be one of the trustees? Not a trustee.
To whom we are giving like, control, people with a good mindset and a controlling power with a neutral attitude. So PMI, they cannot become a trustee here. Yeah, he can become a trustee, but a beneficiary, he'll become definitely PMI.
గారు మీరు వచ్చి మీ
I have she has to manage that house.
Again, ma'am, in your case, like, I'll ask you one very personal question, like, do you believe that after you, that your older daughter will take care of your daughter? See, that is the problem. Yeah. Yeah. Right.
He cannot visit my house
Yeah.
nearly once or twice. That's all.
And is your will registered, ma'am?
No, I did not write even.
Yeah.
Before
So,
writing, I have to thank for
no, in your case, that is like a self-fund then, consider that. Because your husband has given cash and you bought that property, right? So, yeah, fine, no problem at all. It's a self-acquired property. Okay. So the thing is, like, in your case, ma'am, I think you need to write a very good will with a detailed will along with a make it trust. That is the good bagger. No, you can't. In trust, again in trust, you cannot put. Yeah, you can put, like, you can choose your person. While, like, yeah, but outsider will be like, only one outsider will be there, CA. Yeah. Yeah, you can go for it. Na? It's fine, no problem. You can handle from, like, anywhere you are. Okay. So yeah, you can write a will, ma'am. But to be honestly, like, for the more protection after you can go with private trust. That is my opinion regarding your case. Yeah. No, you can make a trustee to your daughters. No problem at all, and beneficiary to her. If she is married, then that's a big question. Then then talk about like her husband and family then.
Thank you. Okay. If you are trusting no one, there is no trust deal. One more thing is, you are putting all your money in a bank. How do you know that bank will survive? How many banks have collapsed? How many cooperative societies have collapsed? And with all your trust, believing that the bank will be lifelong, you are putting your money into a bank. And we are forgetting that you cannot trust yourself. When you trust yourself, morning you are with anger and evening you are very cool, or the reverse.